Good afternoon. You can be seated. The matter before the court is Chalkstone Group, LLC versus Robert Martin et al. This is Somerset 23483. We are being streamed live on the web, both by audio and visual. And I would ask counsel to introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Joshua Dunlap, representing Robert Martin and Charlotte Fawcett.
Good afternoon, Your Honors. Judy Metcalf for the appellees, which are members of the child's family.
Thank you. Counsel, if you're ready to begin, we'd be happy to hear your argument.
May it please the court. This appeal presents a question of first impression. Can a user obtain a prescriptive easement over a road even though, 1, the road's owner imposed maintenance fees, and 2, the user paid the fees upon demand? The relevant facts are not in dispute. The Martin family over the course of a decade charged fees to the Child's family relating to Wildwood Lane. The Child's family in turn paid those fees when asked. On these facts, the prescriptive easement claim fails as a matter of law. The Child's family cannot carry their burden to prove both acquiescence and adversity. First, the Child's family cannot prove acquiescence by the owner. To prove acquiescence, the Child's family must prove, quote, consent by silence, that is, and quoting again, passive assent or submission to the use. In charging fees to the Child's family and others, the Martin family exercised active dominion over their property. Thus, having imposed fees relating to the road, the Martin family did not passively submit to the Child's family's use. Second, the Child's family cannot prove adversity. To prove adversity, the Child's family must show that their use of the road, quote, disregarded the owner's claims entirely. In paying fees when asked, the Child's family acted in subordination to the Martin family's rights. They did not disregard the Martin family's claims entirely, as though they owned the road themselves. It does not matter for purposes of this analysis that the Superior Court concluded that the fees were for maintenance. There is no basis in Maine law for distinguishing between so-called use fees and maintenance fees in determining whether the owner passively submitted to a use or whether the user disregarded the owner's claims entirely. Accordingly, the Superior Court's judgment cannot be sustained. Given the periodic payments by the Child's family, they cannot establish an uninterrupted 20-year period of use. Judgment should enter for Robert Martin and Charlotte Fawcett. I'd be happy to answer the court's questions.
Counsel, my understanding is that in terms of owning the fee of where Wildwood Lane is, that was not actually established or clearly established until 2006, correct?
There was a dispute over that.
Okay. So, and I understand your clients may have thought it was clear all along, but apparently somebody didn't think so, right?
Correct.
So, in terms of those factors of adversity and the like, if you're charging a fee before then, and it's not even clear that they're the owner, doesn't that really go to the idea that it is actually a maintenance and not an access fee?
No, Your Honor, and that is because there is no record evidence that the Child's family ever requested that the Martin family provide any services on their behalf.
Any what?
Any services on their behalf.
Okay, but I mean, but you're talking about it in terms of adversity to the true owner and acquiescence by the true owner. And prior to 2006, it wasn't clear that the Martins were the true owner.
But they were acting as the owner, and it has certainly not been.
From your client's perspective, I don't know if that's true from everybody.
Well, it has certainly not been established that they were not the true owner. It was ultimately settled, the deeds were clarified, but my client certainly has maintained the position that they have always possessed Wildwood Lane. And the important thing for purposes of this case is they acted in accordance with their assertion of rights throughout the record period here.
There was a time when Childs didn't pay the fee in the history of their use. Is that correct?
There have been interruptions, but nothing beyond 20 years, Your Honor. So,
but I'll just ask you, during periods when the Childs didn't pay the fee, whatever it was for, was their access across the road stopped?
There was dispute over that, Your Honor. Ultimately, the Superior Court found that Prior to 1997, they were not necessarily precluded from using the lane. But the important thing is that there was never any 20-year period of use in which they did not pay a fee to the Martin family.
Are you arguing that a payment for maintenance as a matter of law, or for, I guess, either maintenance or access, doesn't matter, precludes a finding of acquiescence or adversity? It seemed to be that you were saying the fact that they're making a payment, whether it's for maintenance or for use, precludes as a matter of law a finding of adversity or acquiescence?
That is correct, Your Honor. And that's because, again, collection of fees is inconsistent with passivity or submission, which is necessary for a showing of acquiescence. It's likewise, there's a demonstration of subordination.
If they didn't ask permission to travel over the road, to the extent that they traveled over the road, the payment of a fee to maintain the road could be characterized in a different way, could it not?
Well, it could be characterized in a different way, but two things are important to remember. First, this court has said that implied permission prevents a finding of adversity. So there doesn't have to be an express statement of permission, and that's very, very important. Second, it is also important to remember that the child's family bore the burden of proof in this case. So if...
Well, that's the question. Is it a fact? That's what I'm trying to get out of you. Is it a fact question, or is it a question of law?
Well, it is a question of law, and the facts as proven, there was no evidence whatsoever that the child's family ever asked the Martin family to provide them a service. So the way that I would illustrate it is this way. If a reasonable person believed that they had ownership rights over a road, and a person approached them and demanded payment for services rendered, that a reasonable person asserting ownership would decline to make payment because they believe that they own the road. If, however, somebody approached them whom they believed had superior rights to their own, and they demanded payment, and in turn they were paid that sum, that indicates that the person who paid those fees recognized.
Well, I'm going to challenge you a little bit on that. Let's certainly in the case, if it had been a deeded right-of-way, and the subservient estate owner, you're traveling along a whole large distance, we've seen the maps, over the subservient estate, and said, you know what, I want you to pay me so I can maintain the road because you're using it too. And the dominant estate, or the person who has the easement, says, okay. I mean, I understand, we're taking it out of the adverse possession, but I mean, there's nothing inherently inconsistent with the idea of paying the person who frankly owns most of the length of the road for maintenance.
Well, what we have in this case, Your Honor, is the owner of the road demanding payment in return for the use of the road to pay for the additional maintenance that it would take caused by the wear and tear of the person traveling over their road.
Well, again, counsel, that's your...
What you just said, though, for use of the road, is that in the record? Is there record evidence that it was put to the child's family in those terms?
I may not have framed that in the best way, Your Honor. What is shown here is that a payment of maintenance fees, because the Superior Court concluded that it was for maintenance, not for use.
And you're agreeing that's a fact question?
Pardon?
You're agreeing that aspect of it is a fact question?
Yes, we are.
Okay.
That's correct. But accepting that that was a fact question that the Superior Court determined, the question now before the court is a question of law. Does the payment of maintenance fees, is that consistent with either acquiescence or adversity?
Why
and we say
can't
no.
two things be true at once? That the child's family is voluntarily willing to pay the maintenance fee, and there's no dispute as to their right to use the road.
Because, Your Honor, we should view this through the precise language that this court has used for both acquiescence and adversity. And for acquiescence, there has to be passivity or submission.
But we've never viewed it in this context.
That's correct. It's never been viewed in this context. So it's a question of first impression before this court. But what I would submit to the court is that you are not being passive if you go to a user of your road and request payment of maintenance fees. It's important to recollect, Your Honor, that this is a rule set for lay people. A neighbor does not necessarily speak in legalese to their neighbor when there's a discussion regarding the use of a road. instead informal conversations occur. And those informal conversations could consist of, pay me some additional money because it's going to cost me more to maintain this road.
Or the conversation could be, hey, would you mind, you guys use the road, we have no problem with that. Would you mind chipping in to help maintain it?
That may also be, but what is known here is that the Martin family went to the Childs family. They demanded payment. That was found by the Superior Court, and the Superior Court also found that the Childs family made payments. And so that is an assertion of
But is there any
control.
evidence in the record here that Martin or one of the owners said to Childs, well before the litigation here, you can't use this road unless you pay this fee? I'm looking through the record here. I couldn't find anything quite as blunt or as clear as that.
It was a disputed fact, Your Honor, and ultimately the Superior Court found that it was for payment of maintenance fees. It was not expressly stated that there was permission granted.
So we don't start with the assumption that that statement was made.
That is correct.
Okay, but doesn't that take us to acquiescence?
We should be looking at acquiescence, and there was no acquiescence because they demanded payment, and they received payment. And under those circumstances.
So does this then turn on whether it's a question of law or fact? I mean, I think I got you down on we agree that the conclusion that it was for maintenance is a fact question.
Correct.
But that your position, and you've already said this, is that a payment for maintenance, as a matter of law, precludes a finding of acquiescence or adversity.
Correct.
If we say that's not a legal question, but rather a factual question, do you lose because there's evidence supporting what the judge concluded?
Well, coming to that conclusion, Your Honor, would be inconsistent with Lyons, which said that it's a question of law to determine what acts of dominion constitute an assertion of adversity. And so the court has already determined that this is a question of law, not a fact.
Why isn't the existence of a, quote, road maintenance agreement as consistent with an agreement among co-owners of a road, one of whom is maintaining the road, the other is paying to maintain it, as it is with permissive use?
The Superior Court certainly found that the 2006 road maintenance agreement supported a finding that it was a permissive use. It was for both maintenance and access, and so the court said that there could be no demonstration.
Oh, it could be, I agree, but it's, I thought your position was paying for maintenance means that it's permissive, per se.
That is correct, Your Honor, and then that was ultimately recorded in the 2006 road agreement.
The court in paragraph 57 of its findings said, and I quote, "The court does not credit defendant's account of the purpose of the fees prior to the execution of the maintenance agreement," end of quote, prior to the execution in 2006. May I
Yes.
continue?
You may,
Okay.
and you actually get to have a brief answer since he's
Thank you, Your Honor. But
in the
certainly
intersection.
the court did find that the 2006 agreement indicated permissiveness. It had found that prior to that, the road maintenance fees were in fact for maintenance rather than for use. But what we submit, Your Honor, is that that distinction is not a distinction that is supported in Maine law. There are 0 cases that support that conclusion.
Thank you.
Thank you.
And Attorney Metcalf.
Good afternoon, Your Honors. My name is Judy Metcalf, and I'm here for the Childs family. This family has accessed this tiny camp on their postage stamp parcel in St. Albans for over 100 years. The evidence was clear that they accessed that camp via the road, a picture of which you have in our brief. There was never any dispute as to the location of the road, never a dispute as to the width of the road, never a dispute as to continuity. Indeed, as the court noted, we had clearly established that we used the road from 1947 on, and that the Martin family hadn't even come into the area and been aware of their use until 1952. As the court noted, the question here, which he just characterized as fervently disputed, was the question of acquiescence. That is a question that is dependent upon a standard of review of clear error. We must give deference to the court which heard the witnesses, saw their poise, heard their evidence. This is not a new question of law to be decided on a flip the coin. You pay a fee, you don't pay a fee. There is a prescriptive easement, there isn't a prescriptive easement. As Justice Horton just noted, in paragraph 57 of the substantial findings here, the judge found that there was no evidence that they had either granted express permission or attempted to deny access at any time prior to the 2006 circumstances, which I'll get to in a moment. The court specifically found that as a matter of law, acquiescence had been found for the 20 years prior to 1997. In fact, he says at least 20 years. And we all know that once an easement by prescription is created, it is as good as an easement by deed. So the question in 1997 is, do we have an easement? The judge found we did by acquiescence, by silent assent. You've heard that perhaps payments over the years ought to have suspended or taken away that right, start a clock setting again. So let's talk a little bit about what the evidence was of payment. The evidence that was of payment for the years prior to 1997 were 3 entries, 60, 61, 62, child's family, road fees, $2.50.
That's from 1952 to 1997.
Right. There are also 2 canceled checks or a cash disbursement statement in the 80s. I don't want you to think that I'm not. So, but by then, we already had our 20 years. The 60s to 84, the court found we had a prescriptive easement by 1997. You can't take that away once you have it in existence. But the evidence was clear that any time fees were paid, they were paid for maintenance. You've just heard counsel for the appellant say that we don't know from the child's family why they paid it, if they requested maintenance. Mr. Jeffrey Childs testified, Robert had a tractor. He graded the road. There was evidence as to the purpose of it. And you're absolutely right, Your Honor, that there was substantial evidence that the Martin family didn't even own a portion of the road that they were maintaining until 2006. They received a deed to that in 2006.
If an owner says to a prescriptive easement holder or prospective easement holder that you have to pay maintenance fees, we keep up the road, and if you don't, you can't use this road, what would be the legal result of that?
That's a different question than what was presented here.
Understood. I'm just trying to nail down the rules of law that govern us here.
I think that the rule of law would be that we have to consider the facts in the context of the evidence.
Sure.
The Jacobs versus Boomer case, which is relied upon by appellants to ask you to create a brand new rule of law, is specifically determined on a clear error basis. My language a moment ago about the trial judge having the best opportunity to evaluate the poise and credibility of witnesses is from Jacobs versus Boomer. So to go to your question,
yeah, my hypothetical question.
You must give me money if you want to use this road.
Even though I'm calling it a maintenance fee.
Right, even if I'm calling it a maintenance fee.
Okay, all right.
That's a totally different case, and I would suggest that if the evidence was that he said those precise words, that may strip you of your prescriptive easement claim.
Okay.
Because it's conditional use. The difference here is we don't have any of that in this case. When there finally is a maintenance agreement that is created in 2006, after the deed from the Schultz family to Mr. Martin, Robert Martin, we have Jeffrey Childs testifying, well, I want to make sure the gate he just put up stays open, as the cable had always been, and I want to make sure he maintains the road. And you've read my brief, so you saw the summary of the evidence of the judge's examination of Mr. Robert Martin about that maintenance agreement.
There's a sentence in the road maintenance agreement that reads, quote, "In return for such payment by the Childs, Wildwood agrees to maintain a passable road and provide access through any chain or gate." If there was already a right to access as of that date, why did the agreement need to say that access would be provided?
Mr. Jeffrey Childs testified that he didn't want to have the type of contretemps that other people in the neighborhood had had. He was mindful that the Schultz situation had finally been resolved, and he didn't want to be involved in something else. As the court noted, that solved the problem for the families for 10 years. It defined what they were willing to do. It expired. The junk car that you've all seen in the photographs lands in front of the gate. For emergencies, call this number. This action was started as a result because we knew we had the rights. And the court found that as of 1997, we had acquired a prescriptive easement.
So again, your
Counsel,
position is
can I
that...
ask you about the historic record of the payments here? I'm looking at the exhibits that, I'm looking at some of the pages that are in the appendix. They go back to 1952.
Correct.
And starting in 1952, there are ledger entries here for fee charged for private road, $28.50. Fee for road use, $41.50. Fees for private road use, $57 in 1954. I thought I heard you say earlier that the court had only found that the Childs were paying in several years in the 60s. So these ledger entries don't reflect transactions with the Childs family.
We don't know who paid the fees that you've just referenced.
But they do.
We know they don't say Childs family.
But they do suggest that at least the Martins were thinking of this in terms of something more than just a maintenance fee, don't they? They're calling it a private road. They're referring to use as opposed to maintenance. Doesn't that sort of shed a light on how the Martins might have been thinking about this?
And the Martin family had an opportunity to enter evidence as to that, to offer evidence, and the court, in the light of the evidence that was presented, found that there was no competent evidence that the defendants or their predecessors were either granted express permission or attempted to deny access. So the evidence led the court to the conclusion that they were not. They hadn't presented, as he said, credible evidence.
Well, the court made a
as to that.
finding, but is it consistent with the evidence? This was in evidence at the...
This was in evidence, Your Honor, and it, the court found that prior to 1997, there was not evidence of any quid pro quo use for fee. He found that in his paragraph. So this is important, and I noted this in my brief. If the appellants had thought that the court had overlooked or not paid attention to some evidence, they could have done a motion for additional findings of fact. They did not. So they have the record, and as you know better than I, you're allowed to conclude that that when the judge made the decision, he was relying upon the inferences he drew from the evidence that he put into his findings. Same situation was in the Jacobs v. Boomer case, which the appellants rely on in suggesting that a new rule of law should be created. In that case, the question was, were the fees for use or were they for something else?
What, if anything, should we put upon the testimony of Charlotte Fawcett, who was allegedly the head honcho, who said she had no information about the purpose of the fees? She didn't charge the fees, didn't know who paid them and to whom, and her only concern was we don't want to maintain the road anymore.
Right, and
what significance does that have?
Well, that's significant in suggesting that the judge heard that and concluded that the fees must not have been for use. He concluded that it was a maintenance fee. In particular, the evidence was very clear that after 2016, Mrs. Fawcett did say, we just don't want to maintain anymore. We're shutting down the camps. We don't want to do it. And as we were very clear at the trial, we're not asking you to maintain it anymore. We get it. You don't want to do it. But you can't cut us off. We own this road. We own the right to use the road. We've been doing it for over 100 years. In the Jacobs case, the court found that there had not been a prescriptive easement proven by virtue of a payment paid to use the landing area. But that was premised upon the facts, not a rule of law.
Does Mr. Martin's deposition shed any light on this? And is that deposition subject to the ancient documents exception?
Well, we spend a lot of time on that in the briefs, Your Honor, and my answer is no. It is not an ancient document that is exempt from the rules of hearsay. It requires us to look at the prior testimony rules, which is the rule under which the judge barred the introduction of that 20-year-old deposition. He found that under Rule 804, the deposition was not admissible. My clients were not parties to the case. They were not in privity with anyone in that case. They never had an opportunity.
Essentially arguing that the more specific rule governs over the more general rule about ancient documents.
They are arguing that.
The judge is finding that essentially the restrictions on the use of the deposition contained in Rule 804 essentially mean it's not trustworthy as we would use that under 803.16.
As we argued in our brief, or I still say we when I'm all by myself.
Can I take you back briefly to Justice Douglas's prior question with respect to the payments in the 1950s?
Mm-hmm.
I just want to understand, you're suggesting that those payments did not vitiate the prescriptive period because A, they weren't made, you're not sure whether or not they were made for maintenance or for access, or because it's not clear who they were made by?
I think it's all the above. There was not competent evidence as to, other than the 3 years I told you, 60, 61, 62, referencing Childs, and other than those 3 years, what were they for? To go back to this question over here, maybe Russell Martin might have shed light on that in his deposition, but we wouldn't have been there to probe. We cannot evaluate the trustworthiness of the prior sworn testimony without having a chance to ask the questions. The appellants didn't even cite Rule 804 in their first brief. The judge did. The standard of review as to his exclusion of that testimony is an abuse of discretion standard. And given the hearsay and hearsay rules, which require us to marry lots of information together, there is no clear error that excluding a deposition at which the appellants and no one in privity were at the table was an error. We could not ask Russell Martin what he might or might not have meant by a conclusory statement. We weren't there. In the same way that you are challenged right now with the question, what were the fees for? You're asking us. The judge had that opportunity to find out from the witnesses what they all said it was for in this case, and he concluded that acquiescence had been proven as of 1997. He concluded that the actions thereafter were for maintenance, but by then they already had their prescriptive easement. I did have one apology I wanted to make to the court. I did make an error in my brief. I mentioned a shovel incident. I cited a shovel incident with Mr. Russell Martin. There was another shovel incident with Mr. Robert Martin. When I did my cite, I did it wrong. It's page 212 of the trial transcript. Thank you.
Thank you. Counsel, I'd like to go to the issue of the deposition, and let me ask you this. Even if we were to find that it was an abuse of discretion or error to exclude it, don't you have to show that there's prejudice?
Yes.
And the deposition's not in the record.
The deposition was proffered. The deposition is Exhibit 25.
But
It was taken under consideration by the trial court and reviewed, so it was properly considered, and there was
But
certainly prejudice.
none of it's in the appendix, is what I would say.
It's not in the appendix, but it is clearly before this court to consider. We quote from it extensively in our brief, and I would make two very important points because it clarifies critical issues here. First, the deponent testified that the fees were for use, which is obviously a critical issue that was debated long and hard, and he was an individual who kept the ledgers, for which there's now dispute over whether or not the child's paid throughout the 1950s. He importantly testified that the child's paid for more than 1 year, that they paid consistently throughout that period of time. And importantly, he also testified that they were given permission to use the road. So when opposing counsel suggests that there is no evidence that there was express permission given, that depends on this deposition being excluded. And if the deposition is not excluded, we have precisely the situation which Justice Mead questioned about, which is, what if somebody said, you have to pay maintenance fees in order to use the road? So this is a critical piece of evidence that was wrongfully excluded. And I would note also, returning again to Justice Mead's question, that it was very helpful to clarify that had there been express permission given, opposing counsel concedes that that would have defeated the prescriptive easement claim. But importantly, the law says that express permission is not the only way that you can grant permission. It can be implied permission, and that is under Almader. So counsel's concession, I suggest, Your Honor, gives the case away, because the requirement that they pay maintenance fees is implied permission. A landowner does not have to engage in legal lease and say, you are expressly permitted to use this road if. It is permitted that they have a more informal conversation, and that's precisely what happened here.
When you say the deposition was erroneously excluded, though, you're saying that it should have come in as an ancient document?
It should have come in as an ancient document, and because of this, there's no dispute.
But didn't the court provide a rationale as to why, even under the ancient document rule, that it would not have been appropriate to admit the deposition transcript?
Well, the court made a mistake, and it believed that it had to assess trustworthiness at the outset. That is what 803.16 sets as a blanket rule, that the court presumes that it is trustworthy and can be admitted if it is over, may I finish the answer?
You may.
If it is over 20 years old, and if authenticity is not disputed. Then it is admitted, and then it is permitted to then impeach that evidence. And opposing counsel has conceded that there was no trustworthiness question here because the child's family was not involved in that litigation. Thank you very much.
Thank you. Thank you, counsel. Thank you for your arguments here today. We will, as is our usual practice, take the matter under advisement and issue a written decision in due course. And with that, we'll be in recess on this matter.
All rise.
And good afternoon, you can be seated. The matter before the court is VCD 23-440, Core Finance Team Affiliates versus Maine Medical Center. We are being recorded as well as streamed live on the web, both with video and audio these days. If I would ask counsel then, who will be arguing in front of us, to identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Gerald F. Petroselli from Maine Medical Center et al. My partner Scott Dolan is here with me at the council table.
Bowles for Core Finance Team Affiliates, LLC. Your Honor, the appellee in this case.
Thank you. And Mr. Petroselli, if you are ready to proceed, we'd be happy to hear your argument. I'm so tempted to say, would you please tell me who sued whom for what, who won, and why?
So far, Core won, Your Honor. Thank you. The fundamental error of the business court, which invalidates the judgment before the court, was the supposition that there was any equitable remedy available to Core Finance in these circumstances. It has been settled in England and America for 500 years that the role of the equity court is interstitial and that it has no role if there are adequate legal remedies. Certainly, Core thought it had an adequate legal remedy for breach of an express contract, which it lost. It also had, if it had any further remedies, another legal remedy in the nature of quantum meruit, which has been an action at law since the early 1600s, long before anybody from England set foot on this continent. It is not simply ancient learning. The Walco-Metroflex decision of this court in 2010 and several others cited on page 12 of the blue brief reaffirm the principle that where there's an adequate legal remedy, there's no equitable remedy. It's clear from Paffhausen, Bowden, Cummings versus Bean, and the Horton and McGehee treatise that quantum meruit is a legal remedy. Accordingly, the court was in error to conduct a separate non-jury trial after the jury's verdict. Among other things, that deprived the hospitals of their constitutional right to jury trial with respect to whatever litigation was going to occur between these parties. I think the one point I would like to emphasize orally here is the contract. There was a contract which carefully delineated the circumstances under which these hospitals could become legally obligated to pay a percentage fee. That's in attachment E to the engagement letter. It's in the appendix. None of those events occurred. There was no opt-in, and the jury's unanimous verdict so determined. There was never any contractual obligation to pay a percentage fee, but more to the point, the contract was designed to protect the hospitals from ever having to pay a percentage fee, because if they didn't take the opt-in steps, they were inoculated from a percentage fee. Nevertheless, in disregard of both the contract and the verdict, the court then resumed proceedings and awarded the percentage fee, the benefit of a bargain that was not made, plus extra money. There was no legal basis for that, and therefore the judgment must be vacated. Moreover, the correct remedy in this court now is judgment for the hospitals, because Core waived the quantum meruit right, assuming it had one.
So what should the mandate say?
Judgment vacated, remanded for entry of judgment for the defendant hospitals with costs.
But there's no denial of the fact that the work was done.
Correct.
And the hospitals benefited from it.
Correct. And they tried to pay for it.
They tried to pay for it?
They tried to pay for it at the usual going rate, the rates they previously paid, the rate they would have cheerfully paid if Core would have accepted it.
So did your opponent paint itself into a corner by waiving the quantum meruit possibility?
I think that's where we are now, Your Honor, yes. And I think given the number of times and the enthusiasm with which the hospital's counsel attempted to clarify the situation for CORE and the court, there's no question that this was accidental or inadvertent or that they should be given some kind of a do-over. That was the strategy, was to avoid getting the standard payment that any vendor would have done this work for.
Where do you think we would have been if they hadn't waived the quantum error?
Well, we'll never know, because it would have been tried to the same jury which said they didn't have a contract, but the most probable outcome, I'm guessing,
And I'm just asking you where you think it might have ended up.
it might have ended up with a jury verdict for $35,000 for CORE. But that's what they waived, to try to get more than $500,000.
Wasn't the way to do this, though, to file a motion for summary judgment on the unjust enrichment claim? In other words, even before trial, your position was, regardless, I mean, obviously, if they succeed on contract, you don't get to it. And if they don't succeed on contract, you still can't proceed on unjust enrichment. I mean, you were saying that all along.
Well, Your Honor, I think that was an option, but as the court has taught many times, the need to be careful about summary judgment. It doesn't take much in the way of a disputed fact to lose a summary judgment, and it is under Rule 12H2, could not be more clear that the issue of the legal insufficiency of the plaintiff's case is in order at the trial, and there was a motion for judgment as a matter of law at the close of the evidence, which is the only procedural requirement needed.
Close of the evidence is the bench trial you're talking about? Or the jury trial?
At the jury trial.
Okay, but does that test the legal sufficiency of the unjust enrichment claim, which was thereafter tried in front of the judge?
Well, Your Honor, the judge had no right to have another trial. It was over
It's
when
what
the
they
jury
pled.
came back. That's the question before the court. Our argument very simply is that the choice to have this other event was legally insupportable. And now, the idea that the hospital somehow or other waived their undisputed right to make this challenge by not asking for summary judgment, which is hard to get, but the court did not waive this claim by aggressively refusing to litigate it, seems unbalanced to me, Your Honor.
CORE is arguing that the jury's finding that the hospitals were not contractually bound, quote unquote, precludes any recovery under any contract theory, including implied contract, quantum meruit. How do you respond to that?
Well, Your Honor, there are two responses. One argument which the hospitals are not making is that might be right. They might not get anything, because people lose these contract cases all the time, and that doesn't mean they get to go over to the equity side and get a do-over on the case they just lost. Or it means that because they lost the express contract, the remedy is to let them drop back to the lesser, in their view, correct in our view, remedy of the quantum meruit.
Well, here, notwithstanding the absence of formal assent by the hospitals, there was evidence that the hospitals accepted the OMS services and actually utilized those services in connection with their reimbursement requests.
I would phrase it differently, Your Honor. With all due respect, the hospital received the services, and the thought, I mean, the services had to be filed with the government. There's a government requirement to disclose this data, and that's what happened. But, and one thing we've stayed away from, but let me go right at it, the deviousness of CORE's scheme to ignore the necessary steps to get an opt-in and not even ask the hospitals, because CORE knew they were going to say, no, we're not going to do it. So they asked a lower-level employee who has no authority to contract for the data, the same person who provides the data for the other piece of work, the average hourly wage work, which was contracted for, done, and paid. So this guy gets a request from the people who ask him for data all the time, and he sends them the data. They had no right to ask for it, and to reward them now would be quite wrong.
As a trial judge, when I had mixed law and equity cases, I always felt it was worthwhile to have an advisory jury to avoid the inconsistent verdicts. Do you have a position on whether or not this should have been tried to an advisory jury if, in fact, the judge was committed to going down this equity avenue?
Well, if but only if the court is committed to including that then an advisory jury with proper instructions and a proper verdict form, a lot of things we could have to speculate about, would have probably been a better way to go because it might have created a different set of options at this point. But the problem is that CORE made these choices. And at this point, it is not for this court to rescue them from them.
Would that have made a difference, though, if there was an advisory jury just on the equitable claim?
Oh, no, I'm sorry, Your Honor.
Assuming that the quantum merit claim had been waived.
I'm thinking no. I'm also thinking that this unjust enrichment, which is not actually a thing, by the way, it's a description of various remedies like constructive trust and so forth. But in any event, if this same jury had been asked some questions, and I can't even begin to formulate them here on horseback, then possibly there would have been some utility in having the jury say something about them. But the point would be that that's an equitable proceeding which is unavailable to begin with. And so getting advice about how to decide something you shouldn't be doing at all seems to me to be really working awfully too hard.
There don't appear to be additional questions.
I would just like to say briefly, Your Honor, that the relevant legal history which has been batted away by the other side, maybe I should have phrased that differently. It's hundreds of years of unanimous precedent in two countries, and that's the history. Thank you, Your Honor.
Thank you. Mr. Bowles.
The court. Again, I'm Lee Bowles. I represent CORE in this matter. This court should affirm the judgment of the business court in favor of CORE. As you have heard, the appellant's primary argument is that the business court erred by awarding judgment to the plaintiff pursuant to a theory of unjust enrichment. An appellant's argument is absolute. And what I mean by that is they characterize in their brief and in argument unjust enrichment as a legally impossible theory of liability in this case. They argue that the only two viable theories of recovery were legal theories, either breach of contract or quantum merit. And that argument, Your Honors, is flawed. To appreciate the flaw, we have to look behind their arguments on both the contract and quantum merit claims. First, both sides in this case concede that there was an express contract in this case. There's no dispute at all that the contract had two different components. One component involved an annual hourly wage work. The parties agree that component formed the basis of a legally binding contract between the hospitals and CORE. The other component involved the OMS work. That is the claim that went to the jury. And the factual issue for the jury was not whether there was a contract. The question was, did each of the hospitals opt in to that contract? And the jury said no. At this point, appellants argue that CORE's only other remedy was to have made a claim in quantum merit, and they further argue that claim has been waived because no claim for quantum merit was asserted by my client, which is true. Even had a claim for quantum merit been asserted, it wouldn't have been appropriate, Your Honors, under the facts of this case. Quantum merit is a legal remedy which allows the terms of a contract to be implied. In this case, you would not imply the terms of a contract because everyone already agrees on what all the terms were. So quantum merit is inappropriate for this case. Appellants seemingly argue that the appropriate payment terms under an implied contract would be determined by a jury, but they wouldn't, because the payment terms, the contingent fee that was in the express contract, was specific and there's nothing to imply, which is why the quantum merit claim was never considered in the first place and should not have been moved or made. Moreover, all of this what I've just said needs to be considered in light of the fact that appellants never raised.
I'm not sure why you're saying that quantum merit would not have been available. The term of the contract that the term of the express contract that the jury found was missing was the hospital's assent to the OMS part of the contract.
True.
And
they did not opt in. That's
The
right.
evidence indicated that the hospitals accepted the OMS services
Yes,
and utilized them.
they did.
And why isn't that a classic quantum merit case? In other words, when there was no express assent to in an express contract, the recipient's acceptance of work justifies a requirement that the recipient pay for the reasonable value of that work.
Because I don't think it's a question under quantum merit that it's assent to the contract. It's clear that, I mean, the jury determined that they did not opt into the express contract. But we can't vary the terms of the express contract that they did not opt into.
There was no contract. That's the whole point. They didn't opt in. So the terms of the contract were not agreed to. And isn't the very nature of quantum merit that services are rendered with the knowledge and consent of the defendant and under circumstances that would make it reasonable for your client to expect to be paid? They did something for them and they expect to get paid. That's the very nature of a quantum merit claim, isn't it?
It is, but in this case, it shouldn't be that way
But
because...
isn't the problem that an unjust enrichment is really for the circumstances where there wasn't an imperfect, if you will, contract where they didn't come to terms, but rather circumstances where there really wasn't, at least initially, an expectation to be compensated, but rather that it would, something does, in the nature of we were talking about services, in the nature of services, it's done, and under the circumstances, it would be inequitable for the defendant to retain those services without some payment. That's the nature of unjust enrichment, right?
The first important nature of the unjust enrichment is it is a remedy when there is no legal remedy available.
And quantum merit is a legal remedy. Is that true?
Quantum merit is in a legal remedy, but it was not an appropriate remedy in this case because there's an express contract.
But isn't it an appropriate remedy precisely where the parties, in what is otherwise in the nature of a contractual relationship, that the parties did not reach an agreement as to, for example, what the person would be paid, and yet the services were rendered? Isn't that exactly what quantum merit is used?
But I do not believe, as in this case, that quantum merit would be appropriate where you had all the express terms laid out in the contract.
Which were not agreed to.
Which the jury said they did not opt into. And then it's compounded, Your Honor, by the fact that quantum merit, the court found that quantum merit was an affirmative defense that should have been asserted by the defendants and was not.
If the jury's decision was dispositive of all contract claims, why isn't that the end of the game for your client? In other words, why do you get to go to unjust enrichment?
Because what the jury said was they did not opt into the contract, so there's no remedy at law under contract. The remedy remaining would be one under inequity.
Well, they did not opt into the express contract as proposed.
They did not opt into...
They were not asked, the jury wasn't asked the question whether there was any kind of other implied contract, which we probably should stay away from that phrase anyway.
So, Mr. Bowles, just to be clear,
does that mean that...
Is it your position that whenever there is an express contract, there can never be a quantum merit remedy?
I think when there is an express contract as here, where there's no doubt whatsoever as to what the terms were, and a jury says there is not a contract, I don't think you would go to quantum merit.
The jury said there's not an express contract.
I'm sorry?
The jury said there was no express contract. There's no express agreement. That's how they were instructed.
They actually said what they didn't do was opt into the express contract. That's what the jury verdict was.
So it seems like then what you're saying is, well, because they didn't agree, in this case, the hospitals didn't agree to pay the fees that were in the proposed contract to which they did not opt in, therefore they can be made to be paid more? That makes no sense.
It does make sense, and the reason is, Your Honor, is because under the contract, as the factual findings, which are reviewed for clear error, the court found that the Corps did extraordinary work, and it considered how normally vendors are compensated for the type of work that Corps was doing. And it determined that the contingent fee that was in the express agreement, which was a 12.5% fee, was actually at the low end of the scale. So under the unjust enrichment analysis for the court, the business court, the question was, what is the benefit that has been conferred upon the hospitals? And it's an extraordinary benefit, as the court found. It's close to $4 million. It's like $3.7 million was the benefit conferred.
Can you just explain something for me in the record that I'm just not aware of? Were the hospitals aware of the fact that the OMS services were being done and they were getting the benefit along the way, or was this something that came up sort of after the fact?
No, I think they were absolutely aware, because that type of work, the OMS work, is discrete work from the annual hourly wage work, so they clearly were aware. There's no question. And so, I mean, that is something that they absolutely knew.
So they accepted and retained that benefit?
They accepted and retained the benefit, which was the reimbursement from the government. Absolutely, they did, yes.
And Corps did not confer that multi-million-dollar benefit on the hospitals.
They performed the service which conferred the benefit.
Which gave them the calculations upon which to submit to get a greater benefit.
Well, that's correct. I think you can't look at it in a vacuum, Your Honor.
Well, I understand, but when you start talking about the benefit conferred in the context of unjust enrichment, I mean, they didn't confer, the Corps Finance didn't confer a multi-million-dollar benefit on the hospitals.
In a way they did, because they performed the service, a unique service, which the court found again to be extraordinary, and without
So
that...
Does that mean that you should have been paid multi-millions of dollars?
No, because the question then becomes what, in terms of the benefits conferred, what is fair? I guess you could argue, I wouldn't argue, that $3.7 million goes to Corps. That wouldn't seem to be an equitable result. The equitable result was, what benefit did you get? What benefit has been conferred? And the court found that the best way to measure that was on a contingent fee basis, not an hourly basis, which would where, if, you know, that's where a quantum merit analysis would arguably bring you. But I did want to finish the point that I don't think we should bypass the judge's point that if quantum merit was a defense that should have been, which was an affirmative defense that should have been asserted and could have been asserted.
How is that an affirmative defense that had to be asserted?
Well, it's an affirmative defense because the argument would have to be, there's no express contract here. That they have been consistent upon that, but there's some compensation that is due.
Why isn't that a second count in your complaint as opposed to an affirmative defense?
Because we were not making the quantum merit claim, because I don't believe it would have been appropriate, Your Honor, where there's an express contract.
So you think the existence of an express contract in any circumstance precludes the assertion of a quantum merit claim?
I think that in this case, I think it does, and I think generally it could, yes. So so the fact that the quantum merit argument was never made, and the court mentioned summary judgments. There was summary judgment practice in this case. There were competing motions for summary judgment filed by each side. Never was there an argument made that the unjust enrichment claim was some kind of inappropriate claim and should not be in the case.
Can I ask you a hypothetical question, sort of a law school kind of question? But imagine someone wants to build a home. They have a contract with a contractor with check boxes about what you want. One of the check boxes is for a shed. They don't check that. Contractor builds a house and he builds the shed. The shed gets built at the end of it, and he wants to get paid for the shed. And the homeowner says, we didn't have a contract there. Is there a remedy under those circumstances, an implied contract or in unjust enrichment?
I think that's more in the nature of an unjust enrichment claim with respect to the shed.
Is that analogous as to what happened here?
I think it is, in the sense that the work, there is an express contract, but here there is no contract. What the jury found is there is no contract for the OMS work. So it's not, your hypothetical is not analogous in the sense that I think you said there was some portion of a contract
Yes, there was a portion of the contract that was done, another portion that was mentioned but not done. The reason I'm asking this is we've said the existence of a contractual relationship between the parties that addresses the sums in dispute precludes recovery under unjust enrichment. That language doesn't say a particular contractual provision. It says a contractual relationship. As long as these parties have something going on, like the homeowner who wants the house built but not the shed, the hospitals want these services but not OMS. Is it enough that there is a contract between these parties, but it doesn't opt in this particular element? Did you follow what I'm saying?
I think so, and I think that I would revisit my earlier answer. I don't think that would, I think that would, the existence of the contract doesn't really have bearing on the shed, because that's its own freestanding claim, if you will.
Contractual relationship, the same, that involves the same subject matter.
Right. Well, in the same way, Your Honor, that no one disputes there was a contractual relationship here. There was a contractual relationship between on the one portion of the work. There's no question about that.
Right.
So,
But there's no dispute that your client had an expectation to be paid for the OMS services, and I take it you would say that that expectation was a reasonable one. And isn't that the primary ingredient of a quantum meruit claim, a reasonable expectation of payment under a circumstance when there is no express contract?
well, my client's expectation, he did have that expectation, but his expectation was he would be paid under the express contract.
Well,
That's
so he knew that that contract they hadn't expressly not opt in, or at least there was an issue on that.
There was an issue. I mean, there was a whole subsidiary issue about whether they were bound by the actions of the Maine Hospital Association.
Let me ask you the same question I asked Mr. Petroselli. Let's assume that we agree with the hospital that this really is a quantum meruit and not appropriately an unjust enrichment, and the measures that therefore that were applied were incorrect. What does the mandate say?
The mandate, I think it would be a remand for a new trial on quantum meruit, I guess, Your Honor. I'm thinking, I mean, it's a little, well, that would be a little odd as I say that, because there's no quantum meruit claim in the case. So I don't think that would be it. I don't know what the mandate would say under those circumstances.
Okay, thank you.
Thank you.
Obviously, there was no quantum meruit claim in the case, and it is nobody's affirmative defense to do anything about the plaintiff's pleading choices. Rule 12H2 and Rule 8 and Rule 12 make all of that clear. The court did exactly what the contract and the verdict said could not be done. Now, the process and the acceptance of services, Your Honor, this is not like a homeowner watches somebody wash their windows. It's a very big hospital. The employee in charge of the data stuff is not the person who makes contracts. The person who would have had to authorize any of this was never consulted, and Exhibit E or Attachment E to the contract, I think it's maybe 125 in the appendix, says that the Hospital Association will give to CORE a list of who opts in, and on receipt of the list, CORE will then confirm that list. Neither of those things happened, and so when Your Honor then collapses this down as though the hospital was a single intelligence knowing everything, the guy who produced the numbers on request, whose job is to produce numbers when requested, had nothing to do with the opting in, and that disconnect makes all the difference to Your Honor's hypothesis.
Well, and the jury agreed with that.
Exactly, Your Honor. And therefore, the awareness is in the sense that the hospital somebody in the hospital understood that somebody was doing the work, but the people who were in the contract making end of the hospital knew they hadn't opted in. And whether they even knew that the work was being done is not shown by this evidence. And as to the extraordinary, wonderful work, the uniqueness of CORE, there's no evidence whatsoever that any of the many vendors in the market wouldn't have done exactly the same thing. There's no evidence that CORE did anything except observe the data accurately and conform to the government's regulations. All of those purported findings are characterizations, not findings, and there's no evidence.
Mr. Petroselli, what if we were to agree that this was an appropriately tried to the court? Would you also disagree with the measure of damages, in other words? And I noted that it was a greater percentage than what would have even been called for.
Well, for two reasons, Your Honor. The one thing the court could not do was give a percentage of the money that the hospitals earned treating their patients, which was paid by the government. As the question I think Your Honor asked was, this money didn't come from CORE. And if we're talking about what's the benefit, the logic of this, which nullifies the argument, if we really want to identify the benefit as $3.7 million, under standard unjust enrichment principles, as in Bowden v. Grindle and the like, they get it all. That makes no sense, so none of the argument makes any sense.
Thank you.
Thank you, Your Honor.
Thank you, counsel, for your arguments today. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, I believe we're in recess for the day.
All rise. All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court, sitting as the law court, may hence depart and give their attendance here at 9:50 tomorrow morning, as this court now stands adjourned. God save the state of Maine and this honorable court.